Fox.
Thank you, Your Honor. Ladies and gentlemen, it is nearly 5:30, and I know you have had an incredibly long day. I saw you all downstairs, down in the courthouse, before 8:30. You've been extremely patient throughout the jury selection process, which took most of the morning. You're incredibly patient in this actual selection process where you were chosen to be on this jury. And now, your job begins. As the judge instructed, he gave you kind of a roadmap, if you will, for this preliminary instructions. Kind of an orientation. I'll tell you the thing I've never liked about orientation. This orientation that you take at school, perhaps in your job, maybe somewhere you volunteer, is that invariably orientation seems to make the task that is ahead of you much more difficult than it is. So that's not the case. I want to keep you centered. Now, as the judge said, opening statements are not evidence. The lawyers are advocates. You are here to determine what happened during an interview that lasted less than 15 minutes on June 16, 2016. That is it. You need to remain focused on that. This case deals with, and exclusively with, those statements allegedly made during this recorded interview. It's 14 minutes long. It was recorded. See, unlike the call that John McCullough made to the GBI in 2016, 10 years after he says these statements were made, it's not recorded. The conversation between the GBI and Mr. Dukes is recorded. You have to hear those questions that were asked, the specific questions asked, and the specific answers that are given. Then after hearing the answers, later will determine what happened on that day, June 16, 2016. But the issue before you is not that Mr. Dukes is charged with burning Ms. Grinstead's body to bones and ashes. He is charged in Ben Hill County in a 3-count indictment that alleges the concealment of Ms. Grinstead's death by burning her body. He is charged with tampering with evidence by burning her body, and he is charged with hindering Ryan Duke's apprehension by burning her body. Those specific allegations, the allegations related to bone and the ash that the state talked about, are in a different county for a different jury on a different trial. And we must not lose sight of it. It bears repeating because it is that important. This case deals with statements made during the interview on June 16, 2016. The issue of whether he burned her body, concealed her death, tampered with evidence, and hindered Ryan Duke's apprehension. Those specific acts are charged in Ben Hill, and again, that is a job for a different jury to weigh on a different day in a different trial. The state and I don't agree on a lot. I'll tell you one thing we do agree is that this case is not about some allegation that Bo Dukes murdered Tara Grinstead. This is not Ryan Duke's murder trial. That begins April 1, a couple of weeks from now. Just as the judge told you, Mr. Dukes sits at that table presumed to be innocent. That is the law. That's where all of this begins. And he will remain innocent day after day until you are given the full opportunity to evaluate the evidence produced by the state. You'll have a chance to wait. You'll be able to view the witnesses. beyond a reasonable doubt, because it is only if the state proves the allegations set forth in the indictment that beyond reasonable doubt, Mr. Dukes will be found guilty. And it is the exact charges in the indictment. All right? When the state charges a crime, a very serious crime, you can't simply convict someone if they prove a different crime, if they prove a second crime. That indictment that Mr. read, just as the judge told you, that indictment is the charging instrument. It frames what the state says Mr. Dukes did to violate the law. And that sets out exactly what they must prove. But you have to keep in mind, if you're dealing only with, as Mr. Grinstead, lies allegedly given June 16, 2016. That's the only issue framed by the indictment, the only one that you are to consider. Based on what the state says, it sounds like you have a lot of information coming your way. It sounds like you're not only civilian witnesses, law enforcement witnesses, forensic anthropologists, doctors, people, things of that nature. It's essential that you remain vigilant throughout this trial in your observations. You must listen carefully to the evidence introduced. Some of it may be very technical, at times it may be hard to hear, but it's essential that you remain diligent listening to the evidence that is presented to you, but also paying attention to where there are gaps in evidence that is not presented to you. Because ultimately, at the end of this case, your job is going to be to take that evidence, to sift that evidence, to weigh that evidence, and ask yourself, is this proof beyond a reasonable doubt that Mr. Dukes committed the exact charges framed in that indictment? Is the evidence I've heard clear? Is it unclear? Is it credible, or does it lack credibility? All right, is this proof beyond a reasonable doubt? These are the things you must keep in your mind. This is your duty. This is the oath you swore to take. The oath you swore to fulfill says that if the state does not fulfill its verdict, does not prove the case beyond a reasonable doubt, it is your duty to acquit. The evidence that is presented concerning this meeting is less than 15 minutes meeting, June 16, 2016. When you listen to the questions that are asked by the GBI, listen to the answers that are provided, you have a chance to weigh John McCullough's credibility, listen to it. That evidence is not going to show you that Mr. Dukes made false statements about some alleged conversation with John McCullough. The evidence is not going to show you that he concealed information with the intent of hindering the apprehension of Ryan Duke. And it is not going to show you that his statements concealed the unlawful death of Tara Grinstead. I'd imagine weeks ago when you opened your mouth, there's notice of jury. You probably got a little nervous when you saw it, a little frustrated because maybe this work is going to be inconvenient, disruptive. But you heeded the call, and you came today. You're downstairs early, came through. You didn't know what to expect. You didn't know what would be expected of you. You're put into a room full of strangers, well, not strangers. Seems like a lot of y'all know each other based on your diet. But you're put into a room with your community. And you're asked questions by lawyers. Sometimes very personal questions. It's not the most valuable thing in the world. But you heeded the call. I'm sure all of you were here earlier when the roll was originally read. There are a lot of names for which there was no response. There were a lot of empty chairs. Perhaps the reason for that is when the call goes out, not everyone heeds it, not everyone has the courage to. But you did. You had the courage to heed the call. You're now the jury in this case. Take an oath. And to do your job is going to take courage. It is going to take courage to weigh the evidence. It's going to take courage to liberate. questions are going to be asked, and I'm going to try to drag this out. I'm going to be a good steward of your time, I'm doing everything I can to defend my client. And I ask two things in exchange for that. First, is that you keep an open mind. That no matter what you've read, no matter what you've heard, only pay attention to the evidence that is presented to you. You will reserve all judgment until you have heard all of the evidence, with the judge instruction on what the law is. Second, I ask that when you are in this box, that you try to keep your mind free and clear of all of the other obligations that you have that you're not able to fulfill because you are serving as a juror. Keep your mind clear of the worries about your family, your jobs. And when you do that, pay attention to the evidence in this case.